Muh Faishal Ibrahim.
Mr. Speaker, I thank members for their support and thoughtful feedback on this bill. To summarize, this bill will bring about 3 key benefits. First, the bill will provide greater convenience to Singaporeans through streamlined registration processes. Second, the bill will cater for an expanded scope of registration scenarios. Third, the bill will strengthen ICA's enforcement powers. Please allow me to address the questions from the members in turn. I thank members for their support of the digitalization of our registration regime. Mr. Zulkarnain Abdul Rahim said that the new digitalized process would reduce errors. This will indeed be the case. This will also save time for members of the public and the public sector. We estimate that a total of about 18,000 hours per year can be saved by members of the public and the relevant government agencies from not performing over-the-counter death registrations. Mr. Gan Tiampo asked whether we will still keep a hard copy of the registration records in case the electronic system fails and the data is lost. While ICA will not be keeping hard copy records for registration done digitally, measures are taken to ensure that the data of the digital records are backed up at alternate circuit sites and retrievable in the event of system failures. Mr. Zulkarnain and Mr. Derek Goh asked whether there will be any extra charges or cost to be borne. ICA will not be charging extra fees. The public hospitals have also committed to not charge extra fees for death registration under the streamlined process. While the government is not able to dictate the fees charged by private hospitals and general practitioners who make house visits to certify deaths, we note that private hospitals and general practitioners will continue to use the same ICA e-service, which they are already using to certify deaths online currently. Hence, we do not expect the cost incurred by the private hospitals and general practitioners to increase. Mr. Goh asked if fees will be imposed for extracts from the registers given that they will be issued digitally. To clarify, the digitalization of documents will start with birth, death, and stillbirth certificates that will be issued when the new Act comes into force. The issuance of digital extracts for births, deaths, and stillbirth that are registered before the new Act comes into force will be introduced in the later phase. Regardless of the format of the extract, there is still a need to recover the cost for providing this service. ICA is reviewing the fee amount. If the costs have come down, the fees will be revised accordingly. Mr. Zulkarnain raised questions regarding the categories of responsible persons and their duties to report births and deaths under the bill. Under Clause 7, where a birth occurs in any premises other than in a hospital, the child's parents and the occupier of the premises who knows of the birth in the premises are responsible for the reporting of the birth. Under the bill, an occupier for any premises includes a person who has control of or is managing the premises. For example, the management of a mall who knows of a birth in the mall, or the owner of an apartment who knows of a birth in the apartment will be responsible for reporting the birth. In most cases, we would expect the parents to be responsible for reporting the birth. Under Clause 22, where a death occurs in any premises other than in hospital, the relative of the deceased person who is present at the death and the occupier of the premises who knows of the death in the premises are responsible for reporting the death. In most cases, we would expect the relatives to be responsible for reporting the death. Mr. Zulkarnain highlighted that for births that occur in a place other than hospitals, premises and conveyances, the responsibility falls squarely on the parents only. However, for the reporting of death in any other place, the responsibility falls on, inter alia, every relative of the deceased person who knows of the death. He asked for MHA's rationale for this difference. He also asked whether the relatives of a child should also be included as responsible persons who should report the child's births under Clause 7, subpara 2. The situations surrounding births and deaths are different. For a newborn child, the parents are the responsible persons who will need to care for the child. Hence, they are legally required to report the birth. Under the current Act, ICA occasionally encounters birth registration by persons other than the parents, such as a relative of the child. While ICA will continue to accept reports of births from relatives who are aware of the births, we do not want to burden the relatives with the legal obligation to report or be penalized for failing to report the birth. This responsibility falls on the child's parents. For a deceased person passing away in any other place, the circumstances of death and the persons who may know of the death may be vastly different for each case. A deceased person could have died alone or in the company of a relative or non-related person. Hence, the provision under Clause 22, subpara 2D, provides for a wider scope of responsible persons than that for births under Clause 7, subpara 2E. As for the scenario mentioned by Mr. Goh of a jogger who finds a dead body, the death will fall under purview of the Coroner's Act as a reportable death, since it is likely that the death occurred under suspicious circumstances. For a reportable death, the jogger is obligated under Section 5 of the Coroner's Act to report it to a police officer as soon as possible. As the death is not under the scope of Clause 22 of the bill, the jogger does not need to report the death to a medical practitioner. Mr. Zulkarnain asked if it would be useful for ICA to still retain some powers to investigate non-reporting offences in cases where there are multiple responsible persons who can report. Under Clause 22, subpara 4, as long as a responsible person reports a death, the duty of every other responsible person is discharged. This is because once a report has been made and a medical practitioner is alerted to the death, the purpose of the reporting requirement is met. However, if no responsible person reports the death, all responsible persons who do not have a reasonable excuse shall be guilty of the offence of failing to report the death. This provides sufficient deterrence against the failure to report a death while achieving the aim of assuring that each death is reported by at least one responsible person. To answer Mr. Goh's query on overseas death, yes, the RG may register the overseas death of a Singapore citizen or permanent resident under Clause 28 if the death is not registered overseas. This provided that the body of the deceased person is brought to Singapore and an application is made by a relative of the deceased person within 3 months of the death, accompanied by a document issued by a medical practitioner that certifies the cause of death and other death particulars of the deceased person. Mr. Gan asked about death registration for missing persons. In the past 5 years, the police received an average of about 1,700 missing persons reports per year. The next of kin of a missing person who wishes to have the missing person presumed by law to be dead will need to apply to the court for the necessary order. This process is governed by the Evidence Act and will remain so. Once the next of kin obtains the court order, they can inform ICA to update the person's status in its system. This information will be shared with other agencies to facilitate other post-death matters. ICA will also issue a letter of acknowledgement to the next of kin when they report the presumption of death to ICA. In the past 5 years, ICA encountered an average of 5 reports per year in relation to such court orders. Mr. Gan asked about newborn children whose births are not registered by the child's parents or who have been abandoned by their parents. In 2020, 72 births were not registered within 42 days. This makes up less than 0.2% of total births in Singapore. Out of these 72 births, most parents do come forward to register the births after reminders from ICA. Due to ICA's effort to trace the parents, the number of cases of parents who fail to register their child's birth is very low. Nevertheless, the bill will provide powers for the RG to register such births on its own volition when the parents fail to do so despite ICA's effort to contact and remind them. As for abandoned babies, such cases are relatively rare in Singapore. The Ministry of Social and Family Development's Child Protection Service will initially place the abandoned baby under its foster care service. Depending on the circumstances of the case, the child may subsequently be returned to the parents or put up for adoption. Mr. Louis Ng asked how ICA will follow up with the responsible persons for a child in cases with incomplete birth particulars. ICA will do its part to contact and remind the responsible persons, but ultimately it is the responsibility of the responsible persons, such as parents, to register the child. Mr. Ng also asked about the naming of a child whose birth is registered by the RG on its own volition. The RG will give the child an identifier, which will be a single-worded name. The responsible person for the child can subsequently apply to the RG to replace the identifier with another name within 7 years of the child's birth. The responsible person can, of course, do so much earlier. Mr. Gan asked whether birth registration and citizenship will continue to be independent of each other. The answer is yes. All births in Singapore have to be reported and registered regardless of the nationalities of the child's parents. However, the policy remains that a birth that is registered in Singapore does not automatically confer Singapore citizenship on the child. In the past 3 years, about 17% of total births in Singapore are those of children born to parents who are both foreigners and therefore do not qualify for Singapore citizenship by birth. There is also a small number of children born to at least one Singaporean parent, but are not granted Singapore citizenship for reasons such as the parents not being legally married at the time of the child's birth. In 2020, such births make up less than 0.15% of total births in Singapore. Mr. Ng asked about children who are stateless. To clarify, children are only classified as stateless when their parents fail to obtain citizenship, Singapore or otherwise, where they fail to obtain the citizenship for the child after the child's birth. A child is not classified as stateless at the time of the birth, nor at the point of the birth registration. It is the responsibility of the parents to obtain the appropriate citizenship for their child. ICA does not keep track of the citizenship status of non-citizen children. Mr. Ng asked about children born to single unwed mothers. Due to privacy reasons, ICA does not specifically share information of such birth with MSF. So let me address some of the questions asked by the Honourable Member, Mr. Leon Pereira, whereby he raised a few issues. One is about for surnames. For surnames, we can have double barrel of different races. On what kind of surnames that are not allowed. This, we follow the same guideline as for names. So as long as names are not offensive, like stupid or Satan, right, then it'll be all right. Yeah, so we are very mindful of that, right, because we want to really protect the dignity of the child. For double barrel race, parents are allowed to register as long as they have different race, register race, right? Need not be across the CMIO categories, right? And this change can be done online for those that were previously registered with a single barrel race. Yeah. And on the suggestion of having more ethnic characters or multiple type of ethnic characters, this is something that we can look into, right? However, as you know, there are some constraints that we have to take into consideration, like space availability on the IC and the birth cert. You also asked about whether we have engaged the undertakers. Essentially, we have been working very closely with the stakeholders. It's not only about engaging them. We receive feedback from the different stakeholders at different point in time, even from the public. So we will continue to engage them, even after the bill is passed. So essentially, it's a continuous engagement, and we are mindful that this is about birth, death, very sensitive. Right? We want to give as much as convenience to the families. So we often receive feedback from the public, the undertakers. Right? We will continue to engage all these stakeholders. And you raise about issues relating to potential delays by medical practitioners certifying death at home under the new death registration process. Essentially, the medical practitioner will be using the same online system which they are doing today. So there is no change. So we have not heard of much of an issue about delay. So we feel that I think it will be business as usual, right? Nevertheless, we will continue to keep on the lookout if there's any delay. You also raise issues relating to the abuse of ICs of deceased. For now, we don't see that as a big issue. We will monitor. In fact, we have high penalties for this. And I think that itself is a deterrent, right, for people who wants to use this, whereby under the National Registration Act, anyone abusing ICs is liable for a fine up to 10,000, or imprisonment of up to 10 years of both. And the other thing that you also asked for data and trends of mixed parentage, yeah? I don't have the data on hand now. Maybe you may want to submit a PQ. And let me see. Yeah, you also raised about the non-digitally savvy. Yeah? Yeah, the relatives of the deceased may request the hospital or medical practitioner to help to print out a copy of the digital death certificate. Nevertheless, we will take note of this feedback. At the end of the day, we want to make sure that everyone enjoys the convenience that we do as a result of this. In fact, when it was first read, I received many positive feedback from even some of the stakeholders who are very involved in such an area. They shared with me that it is very much welcome, and that in itself, especially for the death registration, where they find that it is something that will make it easier and enhance the process of preparing for the post-death matters. And we want to make it convenient for them. birth is a celebration, right? And also now, like what you shared earlier, it's about having all the different parentage, and I think it's about how we can continue to make ourselves relevant. Right? We will continue this process. So I also want to cover an area raised by Mr. Zulkarnain, where he asked whether ICA will be forming a new department to undertake the enforcement of the bill. Investigation officers from ICA's existing enforcement division, which currently already investigates offences under acts such as the Passport Act and National Registration Act, will be appointed as authorized registration officers to conduct searches and investigations into suspected offences under Part 8 of the bill. Therefore, ICA will not need to form a new department. Mr. Speaker, sir, allow me to speak in Malay. Rang undang-undang ini akan memperkemas dan mendigitalkan proses laporan dan pendaftaran untuk kelahiran, kematian dan kematian sewaktu lahir. Ini akan meningkatkan kemudahan dengan ketara untuk orang awam, khususnya untuk kematian apabila seseorang meninggal dunia. Pengamal perubatan akan memeriksa mayat dan mengesahkan punca kematian secara dalam talian. Butir-butir kematian akan dihantar secara elektronik ke Pendaftar Agung Kelahiran dan Kematian yang akan mendaftarkan kematian tersebut secara automatik. Ahli keluarga si mati tidak lagi perlu membuat pendaftaran kematian di hospital, pusat atau pondok kejiranan polis atau penguasa immigration dan pusat pemeriksaan iaitu ICA. Ahli keluarga kemudian boleh memuat turun sijil kematian digital daripada lelaman My Legacy. Ahli-ahli menanyakan sama ada bayaran atau kos tambahan akan dikenakan di bawah proses pendaftaran kematian yang diperkemas ini. ICA tidak akan mengenakan bayaran tambahan. Hospital-hospital awam juga komited untuk tidak mengenakan bayaran tambahan bagi pendaftaran kematian di bawah proses yang diperkemas ini. Walaupun pemerintah tidak dapat menentukan bayaran yang dikenakan hospital-hospital swasta dan pengamal-pengamal perubatan am yang melakukan lawatan ke rumah untuk mengesahkan kematian, kami maklum bahawa hospital-hospital swasta dan pengamal-pengamal perubatan am akan terus menggunakan khidmat elektronik ICA yang mereka gunakan sekini untuk mengesahkan kematian secara dalam talian. Oleh itu, kami tidak menjangkakan kenaikan kos yang akan ditanggung hospital-hospital swasta dan pengamal-pengamal perubatan am. Mr. Speaker, in conclusion, I'm confident that this bill will provide greater convenience for Singaporeans when dealing with births, deaths, and stillbirths. With that, I beg to move.
Any clarifications? The question is that the bill be now read a second time. As many as are of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Registration of Birth and Death Bill.
Committee stage, what day?
Mr. Speaker, now, sir, I beg to move that the Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 69 stand part of the bill. As many as are of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. West Home Affairs.
Has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Registration of Birth and Death Bill.
Leader?
Mr. Speaker, I beg to move that at its rising today, Parliament do stand adjourned to Monday, 26 July 2021.
The question is that at its rising today, Parliament do stand adjourned to Monday, 26 July 2021. As many as are of that opinion say aye.
Aye.
To the contrary, say no. I think the ayes have it. The ayes have it.
Mr. Speaker, I beg to move that Parliament do now adjourn.
The question is that Parliament do now adjourn